Debra's complaint against me was dismissed in front of 7 board members and 15 residents. She received 4 formal violation notices, 1 for each of the open infractions sitting in the public records she did not know I had requested. She spent real money on contractors and HOA fees over the 6 weeks it took to fix them. And the mistake that made all of that possible, the one that set everything in motion, was filing a 3-page complaint about a selfie I took in a floral sundress at a neighborhood barbecue. Because that complaint forced me to request the association's violation records, and her property address appeared in those records 4 times. Before I get into everything that happened, if you knew someone was about to use an organization's power against you in a formal hearing, what would you research first? Leave it in the comments, stay to the end, because the answer to that question is what changed the entire dynamic of that room. Here are 3 moments you are going to see in this video. First, the hearing where I handed each of 7 board members a printed copy of the violation records and watched one of them turn directly to Debra's address on the page. Second, the moment the board president made a point of looking at Debra when she said the words selective enforcement. And third, the board's written statement entered into the official record that the complaint against me appeared to be motivated by personal objection to a neighbor's lifestyle rather than any identifiable rule violation. That statement is in her file, it stays there. Every future complaint she files, the board will see it first. I am 36 years old. I am single. I moved to Tennessee from the West Coast about 18 months ago because I wanted to own something, and I wanted the kind of quiet that you cannot actually find when you are renting indefinitely in an expensive city. I bought a house in a planned HOA community called Cedar Ridge Commons. Nice neighborhood, maintained common areas, a small park with a walking trail, a pool. The dues are reasonable. On paper, it looked exactly like the stable, calm place I was trying to build. I am an online content creator. I have been doing it for 6 years. I started with fitness content, expanded into lifestyle, and about 3 years ago began producing adult content on a subscription platform. Everything legal, everything age-gated, everything created in my own home, on my own time, by my own choice. I have close to 800,000 followers across my platforms. I pay taxes on that income. I operate professionally and completely above board. What I do not do is bring it into my neighborhood. I do not film in my yard. I do not mention it at community events. I moved to Cedar Ridge Commons to have a life outside of work. For the first 6 months, that is exactly what I had. And then people found my accounts, and one person in particular decided to do something about it. Debra has lived in Cedar Ridge Commons for 11 years. I know this because she told me within the first 5 minutes of our first conversation, as if tenure were a credential. She is involved in the association, knows everyone on the block, and has very clear opinions about what this community is and what it should be. Her symbol is the formal note. She sends them actual paper, folded in half, signed with her full name in careful handwriting, the kind of correspondence designed to communicate that the sender is serious and deliberate and not to be dismissed. She had used that same formality when she filed her HOA complaint. 3 pages, single-spaced, annotated screenshots of my Instagram, the performance of reasonableness from someone who was not being reasonable. Her phrase, delivered to my face at the barbecue with the energy of someone who had been building toward this moment for months, was, "This community has standards and you are not meeting them." Her power was the HOA complaint process. Real, formal, capable of putting a violation on my record that could affect my property's resale value. Her motivation was controlling what the neighborhood looked like, specifically whether someone like me got to live in it. Before I tell you what happened when she filed that complaint, I need to explain 3 things, because these are the 3 things that turned what looked like a neighborhood dispute into something Debra could not win from the moment she submitted those 3 pages. Number 1, HOA community standards clauses have limits. The clause in our CC&Rs, the one Debra cited, governs property maintenance, noise, and conduct in shared spaces that directly interferes with other residents' use of those spaces. It does not govern what a resident does professionally. It does not govern what a resident posts on their own platforms from their own home. It does not govern what a resident wears to a community event. Courts have consistently held that HOA standards clauses cannot be interpreted to restrict legal activities conducted on private property or to regulate personal expression in shared spaces within normal standards of public decorum. There was no rule. The complaint was built on nothing specific. Number 2, violation records are public. In most states, homeowners have the right to request and review the association's complaint and violation logs. This information is not hidden. It is not privileged. Any homeowner can ask for it. Most homeowners do not know that. I found out when I was researching my rights and came across the relevant section of Tennessee's HOA statute. That discovery changed what I was able to bring into that hearing room. Number 3, selective enforcement is a recognized legal defense in HOA disputes. If an association enforces a rule against one resident while allowing the same or similar violations to go unaddressed for other residents, that inconsistency can be cited as selective enforcement, a pattern that undermines the legitimacy of the specific enforcement action. If the board was going to consider Debra's complaint seriously, they needed to be aware of what they had been allowing to go unaddressed on the rest of the properties in the community, including hers. When I walked into that hearing room, Debra thought she was the one with information. She had my Instagram screenshots. She had her speech about community values. She had 11 years of tenure and the confidence that comes with being a person who files HOA complaints while the other party has never filed anything. She did not know what I had in the folder. Before I tell you what I found in those violation records, answer me this. Right now in the comments, if you were walking into a formal hearing where someone was trying to use an institution's power against you, what would you research first? Because I want to know what you think the answer is before I tell you what the actual answer turned out to be. The community barbecue happens every summer, an HOA organized event in the common area near the park. I had skipped my first summer. This year I went. I brought a fruit salad. I talked to neighbors I had not met. It was for the first 2 hours genuinely pleasant. I was standing near the dessert table when I took the photo. The afternoon light was perfect, warm and golden, and the kind of thing you cannot replicate indoors, and I had the sundress on that I had been meaning to get a photo in for weeks. I raised my phone, smiled, took the shot, looked at it, liked it, and posted it to my story. 30 seconds later, Debra was standing beside me. She said, "I know what you are doing." I turned. She said, "The photo. I know what it is for. I know what you do, and I need you to stop doing it here." I said, "I took a photo of myself at a neighborhood event in a sundress." She said, "You know what kind of image you cultivate, and bringing that energy to a family event is not appropriate. There are children here." I said, "There are children here, and I am wearing a floral midi dress. What exactly is the problem?" She said, "I am going to be very direct. I know about your accounts, everyone here knows, and I am going to report this to the HOA because this community has standards and you are not meeting them." I looked at her, really looked, the set of her jaw, the brightness in her eyes that was not anger so much as the satisfaction of someone who has finally done the thing they have been planning, and I felt something settle in me. Not anger, clarity. I said, "Please do." She blinked. I said, "Report it. I would genuinely like to see what provision in our CC&Rs I have violated by taking a photo at a community event in a sundress. Please report it." Her expression moved through something I can only describe as surprised indignation. She said, "You think this is funny?" I said, "I think you are going to file a complaint, and the board is going to have to explain to you why my legal profession, conducted in my own home, is not subject to HOA governance. But by all means, I will be at the hearing." She walked away. I watched her talking to 2 other women near the grill. Both of them glanced back at me. I finished my fruit salad, talked to the retired couple across the street, and drove home around 7. On the way, I thought, she is actually going to do it, which means I need to start reading. The HOA notification arrived 12 days later. The complaint was attached, 3 pages, single-spaced, annotated screenshots of my public Instagram, a citation of the Community Standards Clause, an argument that my profession, combined with taking photographs at community events, constituted conduct detrimental to the neighborhood's character. Not a single specific rule cited. Because there was no specific rule, I read it twice. I set it down. I poured a glass of water and thought about how to respond. My first instinct was anger. That is natural when someone files a formal document characterizing your legal career as a community violation. It felt personal because it was personal, but I had learned from 6 years of managing my professional presence and navigating exactly the kind of judgment that comes with my work, that the moment you make it emotional, you lose the thread. The thread here was simple: no rule. Debra's complaint was her opinion about what I should be allowed to do with my life, wrapped in the language of community standards. I called an attorney, a woman who handled HOA and property matters. She reviewed the CC&Rs and the complaint and called me back within 24 hours. She said, "They have nothing. The Community Standards Clause governs property maintenance, noise, and conduct that directly interferes with other residents' use of shared spaces. Taking a photograph of yourself at a community event falls nowhere near that. What you do professionally in your own home is categorically outside the HOA's jurisdiction." I said, "The complaint gets dismissed." She said, "In all likelihood, yes, but go to the hearing and present your case clearly. Some boards are reasonable, some are not. Be in the room." I said, "I intend to be." I spent the next 2 weeks preparing. I read the CC&Rs in full, every clause, every provision. And then, almost as an afterthought, I submitted a formal request to the management company for the public violation log for all units in Cedar Ridge Commons for the past 3 years. And then I found Debra's address. Quick stop here, because I want you to understand exactly what just happened. Debra filed a complaint with no rule to support it. The attorney confirmed I was in the right. I have 2 weeks until the hearing, and I just received a spreadsheet with 43 units and 3 years of violation data, and her address is on that list 4 times. Here is what I found. The first violation 14 months ago, an unapproved fence replacement. Debra had replaced the fence on the right side of her property the previous year without submitting an architectural change request, a clear requirement in the CC&Rs. The violation notice had been issued. No corrective action documented, no follow-up fine. The matter was sitting open in the records. The second, 8 months ago, overgrown landscaping along the back property line, notice issued, no resolution. The third, 5 months ago, a storage shed in the side yard exceeding the permitted square footage for auxiliary structures without prior approval. The fourth, and this one I looked at for a long time, was from 2 months ago. A complaint filed by an anonymous resident about a vehicle parked in the community overflow lot beyond the 72-hour maximum repeatedly over an extended period. The property flagged in that complaint was Debra's unit. 4 violations, the oldest going back over a year. None of them actively enforced, all of them sitting in the public record that any homeowner had the right to request. I printed the records, organized them by date, attached the relevant CC&R section to each one. Then I walked past Debra's house on my regular morning walk. Slowly. The fence was clearly the wrong color. The CC&R specified natural wood tones for all fencing. Debra's replacement fence was painted a dark gray that was not on the approved palette. The shed in the side yard was visible from the sidewalk and was clearly larger than the 6x8 permitted maximum. The landscaping along her back fence line was visibly overgrown. I took photos, dated, time-stamped. I added them to the folder. That night I sat at the kitchen table and reviewed everything. My response to the complaint, the attorney's written analysis, the CC&R provisions with passages highlighted, the violation records, the photos of Debra's property, 43 units, 4 open violations, her address. I was not going to the hearing angry. I was not going to attack anyone. I was going to the hearing with a folder and a very specific question about how this board applied its own rules. The morning before the hearing, I called the attorney one more time. I said, "I have the violation records. 4 open items on her property. I want to present them at the hearing. Is there anything I need to be careful about?" She said, "Present the facts. Do not characterize her. Let the records speak. Your argument is selective enforcement. The board has been processing a complaint against you while 4 violations on the complaining resident's property have gone unaddressed. That is a coherent, documented argument. Make it calmly and let the board draw the conclusion." I said, "I understand." She said, "You are not there to defeat her. You are there to inform the board. There is a difference." I said, I understand that too. She said, you prepared well, go in ready. I wore exactly what I felt like wearing, a blazer over a clean shirt, jeans, my usual self. I was not going to perform respectability for a room that had been handed a complaint about my existence. I arrived early, sat at the front, and set the folder on the table in front of me. There were 7 board members, about 15 residents in attendance, more than a typical monthly meeting. Word had gotten around. Debra sat a few seats to my right with a manila folder of her own and the demeanor of someone who had been preparing for this for months. She did not know what was in mine, and that asymmetry, the folder she could see but had not read, was the only advantage I needed going into that room. The board president, a woman named Miss Patterson, opened the meeting and moved to the complaint item. She summarized the filing. She invited Debra to speak. Debra stood and delivered the speech she had prepared. Community values, families, the character of the neighborhood. She was composed and well rehearsed. She concluded by saying a formal warning was warranted and that further sanctions should be considered if behavior continued. Ms. Patterson said, "Would you like to respond?" I said, "Yes, thank you." I placed my folder on the presentation table. I said, I want to begin with the legal question because I think it resolves everything else. Our CC&R's Community Standards Clause governs property maintenance, noise, and conduct in shared spaces that directly interferes with other residents' enjoyment. It does not govern what residents do professionally. It does not govern what residents post on their own platforms from their own homes. And it does not govern what a resident wears to a community event. I have a written analysis from an HOA attorney confirming there is no rule in our governing documents that I have violated. I placed the attorney's letter on the table. I said, the photograph that triggered this complaint was taken at a community barbecue. I was wearing a floral sundress with a midi hem. I took a photo of myself and posted it to my personal account. If the board believes that violates community standards, I would ask them to point me to the specific provision. I have read our CC&Rs in full and I cannot find it. I paused. The room was quiet. I said, I also want to bring something else to the board's attention because I think it is relevant to how this body considers and enforces its own rules. I walked down the row and handed each board member a printed copy of the violation records. I said, this is the open violation log for Cedar Ridge Commons obtained from the management company through a standard public records request. I have highlighted 4 entries associated with the property at the address of the resident who filed the complaint against me. An unapproved fence replacement from 14 months ago, overgrown landscaping from 8 months ago, an oversized unapproved auxiliary structure from 5 months ago, a repeated parking violation in the common overflow lot from 2 months ago. All 4 violations are open. None of them have been enforced. I placed the photographs on the table. I said, I am not raising this to be retaliatory. I am raising it because it speaks to selective enforcement. My complaint was filed within days of the incident. 4 violations by the complaining resident have sat unresolved for over a year. If this board intends to take a complaint seriously, I would expect it to apply the same standard to every property in the community, including the one whose resident filed the complaint. I sat down. The room was very quiet. 2 board members were looking at the violation records. One of them had turned to the page with Debra's address. Miss Patterson looked at Debra. Debra was looking at the photographs of her own property. Miss Patterson said, "We will take a recess before deliberating." 20 minutes. I sat and drank from my water bottle. Someone behind me cleared their throat. I did not look at Debra. When the board reconvened, Miss Patterson spoke carefully. She said, "The board has reviewed the complaint and the materials presented. It is the board's finding that the complaint filed does not identify a specific violation of our governing documents. The Community Standards Clause does not extend to a resident's professional activities, to photographs taken at community events within normal standards of public decorum, or to the content of a resident's legal online platforms. The complaint is dismissed." I nodded. She said, regarding the open violation records raised during this session, the board acknowledges that these matters require follow-up and will be addressed through the standard enforcement process. The relevant property owner will receive formal notification within 10 business days. She looked directly at Debra when she said that. She said, "The board also wants to note, for the record, that filing a complaint that does not identify a specific rule violation and appears motivated by personal objection to a neighbor's lifestyle constitutes a misuse of the association's complaint process. This board takes that seriously." It has been noted in the file. The meeting moved on to other business. I gathered my folder and walked out into the parking lot. The evening air was warm, my phone buzzed, a text from the neighbor who had told me about Debra's conversations on the street. "Saw the whole thing. You were brilliant." I drove home, made dinner, and went to bed at a reasonable hour. Before I tell you what happened to Debra's violations in the weeks that followed, I want to go back to the question from the beginning. If you were about to walk into a formal hearing where someone was using an institution's power against you, what would you research first? Most people would prepare their defense. They would gather the facts about their own situation, maybe find the relevant rules, maybe talk to a lawyer. All of that is right. But the thing that changed this hearing, the thing that made dismissal inevitable and turned the board's attention toward enforcement on Debra's property, was one additional step that most people do not think to take. I requested the public violation records, not because I suspected what I would find, because I wanted the full picture before I walked into a room where someone else controlled the narrative, because knowing what the board had been ignoring was as important as knowing what I had done right. Every homeowner in most states has the right to request this information. Most homeowners do not know that. Most homeowners show up to HOA hearings knowing only their side of the story. Debra walked in expecting to present her evidence in a vacuum. She did not expect me to have information about her. That is the answer to the question. Public records, the ones that already exist and that you have the right to see. Here is what happened after the hearing, in numbers. 4 violation notices. That is what Debra received within 10 business days of the hearing, 1 for each open item, each with a deadline and a daily fine if the deadline was not met. 2 contractor visits. That is what the fence required. She had to strip the existing coat, which, given how recently it had been applied, was not a simple job, and repaint to the approved natural wood palette. I noticed the work in progress each time I walked past. The final result is technically compliant. Based on the expression on Debra's face the afternoon I walked by while the contractor was working, it was an expensive lesson in reading the CC&Rs before picking a paint color. 6 weeks, that is how long the shed variance process took. An architectural review fee, non-refundable regardless of outcome, was required. The variance was approved because the structure was close enough to the limit, but the process was real and the fee was real. Real money. Between contractor costs and the HOA fees that had accrued during the period of non-compliance before enforcement, Debra spent real money fixing violations on her own property, violations that had been unaddressed for over a year. Violations that would likely have continued to be unaddressed indefinitely if she had not decided to file a complaint about my sundress. One note in her file: the board's written observation that her complaint appeared motivated by personal objection to a neighbor's lifestyle rather than any identifiable rule violation. That note stays. Every future complaint she files, the board sees it first. I want to tell you something about what it feels like to be the person who lives in Debra's neighborhood. There are moments, even now after the hearing, after the outcome, when I wonder what it would be like to live somewhere that did not require this much armor. Somewhere I could move through my days without calculating how people are reading me. Somewhere I could be a neighbor without someone deciding my legal career made me a community hazard. There are moments when the weight of it is more than I want to carry. And then I think about the attorney I called the day the complaint arrived. Not the legal analysis. I knew the legal analysis would come out the way it did. I mean, the moment she paused at the end of the call, after we had gone through everything, and said something that I have thought about many times since. She said, "You know what the most important thing you can do before any formal dispute is?" I said, "Document your conduct?" She said, "Read the documents you signed, all of them, because most people in disputes over HOA rules have never actually read the CC&Rs. They show up to hearings relying on what they think the rules say. You showed up knowing what the rules actually said. That is not common. That is the whole game." I have thought about that a lot, not because it was clever, because it was simple. Read the documents, request the records, show up prepared. I still live in Cedar Ridge Commons. I still walk the trail in the mornings. I still wave at the neighbors who wave back, which turns out to be most of them. I still take photos when the light is good. Debra and I no longer make eye contact on the walking trail. We have not spoken since the night of the hearing. There is an equilibrium to it now, not warmth, not open hostility, just the particular neutrality of two people who live within shouting distance of each other and have both decided that the distance is working fine. I used to wonder if I should try to close it. I no longer wonder that. Some distances are right where they are. I took that photo in a sundress at a barbecue. I still have it. It is a good photo. I still like it. At the beginning, I asked if someone was about to use an institution's power against you in a formal hearing, what would you research first? The answer is whatever public information that institution holds: violation logs, complaint records, meeting minutes, any document the organization produces that is available to members or residents. Most people do not know these records exist. Most people do not know they have a right to them. Most people walk into HOA hearings knowing only their own story. Knowing the full picture, including what the board had been ignoring, changed everything in that room. It shifted the conversation from whether I had done something wrong to whether the board was applying its own rules consistently. Selective enforcement is not just a legal concept. It is a visible pattern in a spreadsheet. And when you can put that spreadsheet in front of 7 board members, the conversation changes. Read your CC&Rs before you need them, not because you are planning to dispute anything, because you signed them and you should know what they say and what they do not say. The absence of a rule is as powerful as the rule itself. Most HOA complaints cite clauses that do not actually support the enforcement action being taken. Knowing that before you walk in is not aggressive, it is prepared. Know your right to association records. In most states, homeowners can request complaint and violation logs from their management companies. Ask for them. They are informative before any dispute and essential during one. Document your own conduct. If you know you are in a situation where someone is likely to misrepresent what you do or how you live, keep records of your own. Photos, timestamps, copies of everything you submit. Not because you expect a hearing, because if a hearing happens, you want to be the person with a folder. And the last thing, the one I keep coming back to, other people's discomfort with your legal choices about your own life is not a violation. It is their discomfort. It belongs to them. You are not required to shrink yourself to accommodate it, to apologize for existing in a space where they would prefer you not to, or to accept that their opinion of your profession constitutes a rule you have broken. It does not. It never did. I moved to that neighborhood to have a home. I still have it. I still walk the trail in the mornings. I still post the photos I want to post. So I want to hear from you. If a neighbor filed a formal HOA complaint about how you present yourself, your clothing, your career, your social media, what would you do? Would you fight it? Move? Something else? And did you look up the answer to the question from the beginning? What would you research first if you were walking into that hearing? Leave it in the comments. I read every one.